Hello, I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines, where my law partner Sean Fagan and I are discussing legislation that has passed the House, is now in the Senate, and if the Senate passes, will go to Governor Edwards. Frankly, it's bad legislation. It would hurt victims in legislation. It would make the litigation more expensive for you, possibly eliminate your ability to have a judge try your case, and the worst part is punish you for having your own health insurance or perhaps disability insurance. So join us on the next Legal Lines with my law partner, Sean Fagan.
One of the reasons I love this firm is that the moment you walk through the doors, you're so much more than business. You're family, which means we're going to fight for you as if you're family.
Most of the people we represent come from past clients who have referred friends, family members, other people they love to us to represent them in the same way we represented the persons who referred them.
We all pull from each other's experiences, knowledge, the law, so that we get you not only a solution to your problems, but the best solution that we can come up with for your problems.
Knowledge is power, and the folks who know what they're doing empower you. They enable you to make the right kind of decisions that best serves you. And that's our number one goal, frankly. Our number one ministry is to serve you. Hello, I'm Locke Meredith. Welcome to Legal Lines. I'm very pleased to have back on my show Sean Fagan, my law partner, and we got some things to talk to you about. Sean, hi buddy. Good to tackle this issue with you.
Actually, yeah, that's what I'm a little passionate
several
about.
Issues. Kind of to start off, let's figure out, or describe rather, kind of what a law is. Explain to folks in just, lay terms, what a law is.
Well, at the state or federal level, it usually starts off in one part of the governmental process on the legislative side of either the House or the Senate. House maybe creates a bill, they vote on it, they pass it, it goes to the Senate. Senate can do the same thing, pass it back to the House, they go back and forth on committee, and then if they have agreement, the House and Senate, if they agree on the language, then it goes to the governor for signature, or the president if it's national.
And as pointed out, you actually served as a Senate aide. The United States Senate a good number of years back.
Yeah, many years ago.
Got to watch that wonderful process. It's kind of like making sausage, sadly. And so to summarize it, bottom line is you got the House. They're the originators of the bill.
Or can be. It can be. Either one can do it.
And they have committees look at the subject matter, and then they'll fight over language. If those committees vote, and then if they send it up to the full body, whether it's the House or the Senate, and then a majority vote again, and then it's sent to the other part of the House, or the legislature rather. You got the Senate and the House. So if the House does it, they'll send it to the legislature, like you said. Senate passes it, they'll send it to the House. Then they fight about the language. If they agree, goes to the governor. What are the governor's options?
Governor's option either sign it, and then it becomes law. He can not sign it, in which case over a passage of time, it becomes law, or he can veto it.
Right. And so that's the bottom line. And law is an exercise of power over people or their businesses or their things, property, by the government.
That's right.
And the law is usually granting rights, modifying rights, or taking rights away. And whether it's regarding the person and the rights that the person has, or protection of properties or whatever. So we've kind of described the process as best we can, and frankly, we've got our legislature in Louisiana working hard up there, and so they're tackling a few issues that frankly have raised concern for us because few of them are fine, a couple of them are not fine because it, in our view, is not fair to the victim of someone who's hurt because of the negligence of some other party. So let's describe first the ones that, you can take it or leave it. One is good, in my view, and that is the House has passed a bill and now sent it to the Senate to consider that extends from 1 year, 2 years, the time period you have to sue the person who may have caused you damage.
That's right. I brought my prop for the day, which is it's our House bill that was really just passed just in the last few weeks.
It is called the Omnibus Premium Reduction.
Correct. It's a House Bill 372, And one of the concerns is that it doesn't involve just one aspect. It changes several laws simultaneously. This bill covers 5 or 6 different areas that we wanted to talk about
Well,
today.
let's talk about too the fact that its name tells you kind of what's going on. It sounds like there's the promise by the insurance company, because they're talking about omnibus premiums. Premiums are paid to insurance companies, and it's a premium reduction. So it's telling you, insurance companies saying, hey, if you do these things, we'll reduce our premiums to provide automobile insurance or homeowners insurance or all kinds of stuff. But we need you to do these things, and then we'll consider reducing our premiums. There's no promise in there or guarantee that they'll do that, is it?
It's even worse than that. I've spoken to some legislators about this particular bill, and there's no promise whatsoever from any insurance company that they're going to reduce premiums. It's kind of like the field of dreams. If you
Kind of like
build
the
it, they'll
Medical
come.
Malpractice
Yeah.
Act that was passed in the 70s.
Correct. The whole idea of the Medical Malpractice Act was you limit damages to $500,000.
They capped the amount of damages a victim could get. You're a little girl, you get your leg amputated, the jury awards $4 or $5 million, and all you get is $500,000.
Correct. And we've had a case like that.
We
And
sure have.
And
You
so,
tried
and so,
it.
what's frustrating about that is that same cap has been in place since 1976.
And the premiums have done nothing but this.
Premiums, it did not really reduce premiums. All the thoughts that the legislator had regarding the justifications for making that cap haven't come about. The doctors are still paying huge premiums for liability insurance, and so really the truth is that there were caps put in place that benefit really the insurance company in that case, but it didn't benefit the doctors because they're still paying huge premiums.
Certainly didn't benefit the victims.
Nope.
And let's talk about the victim versus an insurance company. A victim, for example, the case with the little girl whose leg was amputated because of the negligence of a doctor. Her damages are $4 million, $5 million, and yet all she gets is $500,000. That one little bitty victim girl, that little 14-year-old girl, is instead of getting $5 million, getting $500,000. She's bearing the whole loss. Whereas if she was awarded that $4 or $5 million, there was insurance companies there to pay it. Why? Because they get premiums from hundreds of thousands, if not millions, of people in America. Their whole purpose of an insurance company is to spread the cost, the risk, the harm amongst hundreds of thousands of people, if not millions, instead of making one victim bear the full
That's
price
right.
for
That's
doing
right.
nothing wrong.
And the irony of that, of course, is she was 14, but if the person was 74 instead of 14, would have still gotten $500,000. And so you think of the effect on a 14-year-old over the
For the rest of
for the
her
rest of her
life,
life in terms of being able to
literally.
get jobs and things like that, whereas someone who's 74 may be retired at that point. Not to minimize the loss, but the economic impact for a 14-year-old is much greater, and you only get
And the
same-
medical expenses, the medical care for the rest of her life.
Now, the medical care is something that's not capped, but really the truth
But
is,
you
like
don't-
in her case, the medicals were ended, but it was the impact economically on her in terms of earning ability, things like that, for the rest of her life that the award couldn't even touch.
Well, let's talk about first of all the couple of things that you can take a leave. We talked about the fact that they've extended, or they're proposing extending from 1 year the period to 2 years within which a person who's injured or caused harm by the negligence of another party to file a lawsuit.
That's right.
I don't think there's anything wrong with that.
That's good. Louisiana
Agreed.
Louisiana is one of the few states in the entire country that has a 1 year, what we call prescriptive period. If you don't bring the action within 1 year of the injury, with certain limited exceptions, you've lost the right to bring the action at all. But most other states have 2 and some have 3 and longer years that you can go before you have to file a lawsuit.
They're trying to eliminate the ability for an injured party, a victim, to have what they've done is reduce the jury, the amount of damages that entitles you to a jury. 50,000, 5,000, explain.
And that's bad. And look, even before we get to that, and I'll tell you why, we're not beating up on this bill completely. The topic we were just talking about, increasing the time period from 1 to 2 years, that's good because it gives people longer time to figure out how much they have in damages. But we hit that later.
All right, we'll continue this on the next segment. This is Locke Meredith with Legal Lines. My special guest, my partner, Sean Fagan. We'll be right back.
One of the reasons I love this firm is that the moment you walk through the doors, you're so much more than business. You're family, which means we're going to fight for you as if you're family.
Most of the people we represent come from past clients who have referred friends, family members, other people they love to us to represent them in the same way we represented the persons who referred them.
We all pull from each other's experiences, knowledge, the law, so that we get you not only a solution to your problems, but the best solution that we can come up with for your problems.
Knowledge is power, and the folks who know what they're doing empower you. They enable you to make the right kind of decisions that best serves you. And that's our number one goal, frankly. Our number one ministry is to serve you. Welcome back to Legal Lines. I'm Locke Meredith. Pleased to have on the show again my law partner, Sean Fagan. Sean, we talked about the change of, at least proposed change to the prescriptive period to file a lawsuit for injuries or damages from a tort, a negligent act. And the proposal is going from 1 year to 2 years within which you have to sue. Explain why that's probably pretty good.
Well, if what we're trying to do is reduce premiums, which is what the Act says it's trying to accomplish, that's probably of the 4 things that they're suggesting, the one that's most likely to do that. Why? Because when folks are forced to file a lawsuit within 1 year, sometimes it's premature.
Exactly.
You haven't developed the damages yet or figured out how bad the injuries are. If you have 2 years, you have more time to kind of consider it. The adjuster for the insurance company has more time to consider it. They don't have to hire counsel. They don't have to get into a lawsuit that costs money. They can do that much less expensively by dealing one-on-one.
It benefits both parties,
yeah,
really.
it
It enables
benefits
them to collect the information necessary to discuss possibly resolving it amicably.
That's right.
Without litigation and the cost of litigation and the delays related to litigation. So that's a good one. We're cool with that.
Yeah, I think that accomplishes the purpose they're trying to accomplish.
So let's talk about changing the jury threshold from currently 50,000 to 5,000. Give me your thoughts about that.
That's probably a disaster.
Explain why.
Right now, if a case has a value of 50,000 or less, it can be tried by a judge. If it's 50,000 or more, you have the option to have it tried by a jury. By reducing that amount down to 5,000, what it means is you've essentially taken judges most of the time out of the equation.
They can't possibly be happy with this.
It's hard to say.
I mean, would you want to sit there and sit through jury trial after jury trial after jury trial when you could, for days on end and weeks on end, when you could read depositions and resolve it quickly?
Well, that's where you hit the nail on the head. The bench trials, as we call them, judge trials, are much more efficient.
So explain why to folks.
Well, the reason why is because when you have a damage claim that's 50,000 or less, they're they're usually much less complicated. And so you can submit to the judge before you go on the day of trial. You can submit depositions, you can submit arguments, papers that the judge can read, so that when you walk in, a case that might have to take 2 or 3 days of a jury's time can be tried to a judge maybe in 3 or 4 hours.
And again, the main reason is, you mentioned depositions, and really what that is that's the testimony of a witness that either saw the accident or the experts hired by both sides. It's a way to submit to the judge the communications of the witnesses and the experts in the most succinct way possible.
Correct. In other words, you can bring depositions to a jury, but they have to be read to the jury, and which is probably the cure for insomnia, right? Someone reads the deposition to you, a juror falls asleep, understandably. And so a judge is used to reading things like that, can go through to the most important pieces, synthesize that, and come up with a decision much more quickly. And so by dropping the threshold from 50 to 5, you've pretty much lost that opportunity. And if you're a citizen, all right, right now,
I just did this.
Oh, look,
I'm glad I had the chance. It was a great duty to serve on jury duty, but
But it is for people who are working and they're getting an hourly wage. Now look, don't get me wrong, you get paid $12 a day if you serve on a jury.
Let's say that again, $12 a day?
$12 a day. So I'm sure people are lining up to say, let me give up my job for the day to go earn $12, which by the way is still taxable, but it's taxable income. So, but the big point of it is, right now, if you serve on a jury, I think you have a 3-year period of time that you won't be called to serve on another jury unless you volunteer. If you're having juries for every single case that's worth more than $5,000,
They used to be handled by the judges.
They were handled by the judge.
Because they're cheaper, faster.
More efficient. Now what's going to happen is you're going to have jurors coming in so much more frequently. So it's possible you could be called for jury duty 3 times a year. And in terms of someone who has a job and you're trying to explain to your employer, that you need to take off, and it could be for 1 day, 2 days, 3 days, who knows?
Well, and I just taped a show, last set of them, with Mona Collins, the jury coordinator.
That's right.
Jury duty coordinator. And you're just not paid a lot, and the employer is only obligated, I believe, to pay you for 1 day, and the rest of that time you're eating it.
That's correct. That's correct. And don't get me wrong, to be able to serve on a jury is probably one of the most educational things you could ever do.
Well, and it's a responsibility and a duty, and you should
right.
do it. But I'm not sure everybody, from an economical standpoint, could do it as much as is required if this goes down.
If this passes. So I think that's it's a problem for efficiency and also for the public, because when you're trying to do the logistics of doing all these jury trials, juries have to be instructed on the law. The evidence has to be given to them in a certain way. Then they have to have closing arguments, which judges a lot of times say, I don't want to even hear them. I understand the evidence, I'll make the decision. Then you give the jury instructions at the end of that. So when it's all said and done, what could be done in 3 or 4 hours by a judge, again, takes 2 or 3 days.
And it's also more expensive
Yes.
for the person who is having to provide the jury bond and pay for the jurors' meals and all of that. I mean, it is not only much more time consuming and less efficient, it's a lot more expensive.
Yeah. And if you're a witness and you're subpoenaed to come in, you have to come in for that jury trial and sit around until you're called, whereas if you take a deposition and it's a bench trial, the witness who has no involvement in the case at all, you don't want to make that person miserable by having to sit in for something that they're just, as a good Samaritan, coming and testify about. So a lot of things like that really
think
affect
also
everyone.
about the medical experts. If they come to testify live, they're going to charge you $10,000.
Yes.
Whereas you might pay $1,000 or $2,000 if you're lucky to present that evidence by deposition.
That's
so
correct.
Clearly, this is a serious potential change in the law that, frankly, in our view, doesn't benefit the general public, certainly doesn't benefit the victims.
And it doesn't accomplish the idea of lowering premiums in any way that I can see. So
I think it's a good analysis. Let's talk about the proposal to eliminate the direct action statute, the ability to directly sue an insurance company who's providing, say, liability insurance coverage in an automobile wreck to the at-fault party.
Yeah, I think that is one that a lot of people, it's subtle. It's a subtle thing.
It is subtle.
But it's a big deal because the push for that is mainly coming from an insurance industry to leave jurors, or mainly jurors, with the perception that the person who's been sued may not have any coverage at all, because you don't know. It's just Jack, Johnson has been sued, and you don't know if Mr. Johnson
whether they
has
get insurance or not, because you weren't able to sue the insurance company, and the jury doesn't see that.
And you're not allowed to put that into evidence when they take away the direct action statute. So it's a big deal because it's hiding information from the jury that might affect them.
And there was another component to the analysis, that if you eliminate direct action, there may be more federal court litigation.
Yeah, that's another big deal, because if you have the misfortune of being hit by somebody from out of state,
Which seemingly these days, defense insurance companies want to be trying litigation in the federal
in
court.
the federal court, and so when they're
How
hit,
does that reduce premiums?
That's the whole point. If this is the motivation behind this act, it's not accomplishing it by doing that.
All right, and so first one we like, prescription, jury threshold change, don't like, direct action, don't like, and this last one is a biggie, and that is eliminating the collateral source rule. And we'll discuss that in detail in the next segment. This is Locke Meredith with Legal Alliance, my law partner Sean Fagan. We'll be right back.
One of the reasons I love this firm is is that the moment you walk through the doors, you're so much more than business. You're family, which means we're going to fight for you as if you're family.
Most of the people we represent come from past clients who have referred friends, family members, other people they love to us to represent them in the same way we represented the persons who referred them.
We all pull from each other's experiences, knowledge, the law, so that we get you not only a solution to your problems, but the best solution that we can come up with for your problems.
Knowledge is power, and the folks who know what they're doing empower you. They enable you to make the right kind of decisions that best serves you. And that's our number one goal, frankly. Our number one ministry is to serve you. Welcome back to Legal Lines. I'm Locke Meredith. Again, very pleased to have on the show for the probably umpteenth time my law partner, Sean Fagan. We're talking to you about some serious stuff, though. There's proposed legislation. House has passed some stuff that's now before the Senate. And frankly, you need to contact your senators. We hope you listen. So let's talk about this one. This proposed change is a big deal, and it's basically eliminating the collateral source rule. Explain to folks what that is, Sean.
Right. Collateral source would be something that you're paying for out of your own pocket. Like, for instance, health insurance. You pay a premium every month to protect you against harm. If you get hurt, you have to go to the hospital.
Let's think of all the things that fall within this definition. You're paying for a coverage of a possible risk or expense you're going to have. Mm-hmm. And this new law wants to punish you for that.
Yeah, the way the law is right now, it says if I hit you in my car and I hurt you, and you happen to have health insurance, you've been paying health insurance premiums for the last decade, haven't ever had to use it.
Right.
But the one time you have to use it after paying thousands and thousands of dollars in premiums.
Or disability insurance or any other type of program like this.
Anything
for
like
lost
that.
income.
Yes. And so you've protected yourself and you've paid handsomely to have that protection all these years. Now it comes time for you to have the opportunity to take advantage of the fact that you've been paying those premiums. Well, I would have to pay you for any damages I've done. If you've incurred $2,000 in medical bills, I'm the one that caused the accident. It's fair that I pay your $2,000 in medical expenses. If you have health insurance, you get a chance to go to your health insurance carrier and say, hey, look,
I've incurred these medical expenses, pay them.
Yep, and your health insurance would pay that. What this proposed law would do is I would now be able to benefit from the fact that you've gotten health insurance. You've paid all the premiums, and if your health insurance covers all $2,000 of your expenses, guess what? I don't pay anything for your medical expenses.
Now, in reality, most of the times when a health insurance company pays those medical expenses, they do their job and they find out your injuries were, say, the result of an accident in an automobile, and they lien your case. They first send a lien letter to your lawyer, and then they can actually be involved into the litigation if they want to.
Correct.
They protect their interests. They say, you, tort fees, guy that hit my guy that I paid medicals, you pay that money to me. I paid it, here it is.
Yep, in which basically they say reimburse us for everything we paid for Locke's medicals.
And it's interesting too, because usually the health insurance company pays less for that medical treatment than you would normally have to incur. Mm-hmm. If you just didn't have health insurance.
Yeah, the example would be...
So again, the defendant is benefiting.
Yeah, and it's really, in this case, that's the crazy thing about this is to the extent this could reduce insurance premiums, it would be doing it on the backs of people who are paying insurance premiums for other types of coverage.
Being responsible, saying, I recognize this as a risk in my life. I may not be able to earn money because of an injury, so I'm going to get disability insurance. Or I may need medical care. I got to get some health insurance. I'm going to pay that premium. And instead of rewarding that behavior, they're punishing you.
Yeah, and it was the way the law currently exists is the law says, look, when you're hit with a situation like this, where the medical bill has been paid by someone's health, in your case, the example I was using, I've struck you with the car, your own health insurance, Blue Cross Blue Shield, whatever it may be, pays your health bills. I would typically have to pay that to you even though you had health insurance. Now you say, well, why do you get that money? Well, the reason why is because there's a question of who gets to benefit.
Well, and I paid the premium for that benefit.
That's what the law is right now.
That guy over there sitting there in that chair who hit me, he didn't pay a penny.
That's right. And so the law and this isn't Louisiana, this is across the 50 states. And so this provision, this proposed legislation, and whatever, House Bill 372 or whatever it is, proposes that gets thrown out. And that would put Louisiana, this is such a radical change. This would be one of maybe 3 states out of 50 that do this. I mean, this is rarefied air, and it doesn't help the people.
Sean, earlier you mentioned that their argument is prevent double recovery, but it's really not double recovery because you're paying premiums for the ability to have those expenses paid back or lost wages paid back. And the other side of it is, and the reason the purpose for the collateral source rule is you want to deter bad behavior or negligent behavior. A kid who's burning rubber as he takes off at a stop sign or runs a stop sign or is going 100 miles per hour. He's going to benefit because you were smart enough to be responsible enough to buy disability insurance? It makes no sense.
Well, it turns it on its head, right? Because what you're saying is you want the person to be responsible for all the consequences of their negligence.
And certainly not be benefited by the negligent act.
That's where this becomes a little crazy, right? Because you're saying, look, if you've hurt somebody, you should be responsible for all the harm you've caused. If you say, well, that the harm you caused is actually now transferred to the person who you hurt, and they're going to pick up part of the tab for it, that makes no sense. And at the same time, when you're taking away some of the consequences from the person who caused the harm, now you're putting a burden on the person, so you're discouraging good behavior.
Right.
The good behavior is buy health insurance.
That's right.
Pay premiums. Don't say, well, why do I want to do that? Because if I get hurt, it's just going to benefit the guy who hurt me.
Well, you notice another excellent or concern or problem with the proposed legislation regarding the collateral source rule.
Yeah, well, again, this would put Louisiana in rarefied air.
I mean, we're already there, right?
Yeah, I mean, if this passes by itself,
we're always
it's
the worst
bad.
at everything.
Well, I shouldn't say that, but this particular law is not well thought out. But what it would do is say, okay, let's just say you have the misfortune of the attorney that you hire doesn't realize that you should submit this to your health insurance
or disability insurance, or whatever.
Or whatever it is, whatever type of
that
coverage
pays for your losses.
Whatever type of coverage you've been paying for the last decade. Doesn't realize you have it, maybe didn't ask the question. And so then you go ahead and you get this this verdict or this judgment in your favor. It can be reduced if you have not submitted it to your own health insurance carrier, for using that as the example. So now, it's even worse.
You didn't even get the money. There was no double recovery. You're going to get tattooed.
Yeah, that's right. I mean, it's filleting the innocent victim in that sense. So, you didn't realize it. You didn't go to your health insurance. You didn't ask them to pay for your medicals.
Or Sean, alternatively, let's say I did know it was there, but I said, heck, that guy's going to pay me my medical expenses. He's got insurance. I confirm that. I don't want my premiums to go up as I continue to pay for this coverage.
And we hear that all the time. We have clients that say, I don't want to put this against my own health insurance because it's a claim and they're going to up my premiums.
Or their own property damage insurance for their vehicle because they know they possibly could get charged more.
That's right.
It's not an unreasonable position at all. And yet with this proposed legislation, you're going to punish the victim.
House Bill 372. Folks need to understand what this is about and realize it's not going to accomplish what they say they want to accomplish.
Folks, this is bad law, and we highly recommend you contact your senator now. This is pending in the Senate, and if it passes there, that we let Governor Edwards know this is not fair, this is not right. Thank you for joining us on Legal Lines with my partner, Sean Fagan. Sean, enjoyed it.
All right, buddy.
See you next time.